Hello, my name is Martin Egelhoff. I'm a judge with the Denver District Court in Denver, Colorado. Other than the voir dire process of jury selection, jurors are limited in their ability to interact with the parties or the trial judge during the course of a trial. Two exceptions are the jury's ability to ask questions, either witnesses during the course of the presentation of evidence or the court during the course of the jury's deliberations. If properly implemented, the ability of the jury to ask questions in these contexts can engage the jurors in the trial process and enhance their ability to understand the law as they endeavor to reach a proper verdict. Rule 24G of the Rules of Criminal Procedure, which govern jury questions, is comprised in two parts. First, it provides that jurors shall be allowed to submit written questions to the court for the court to ask to witnesses during trial. Second, the rule grants the trial court discretion to prohibit or limit questions in a particular trial for the reasons stated in the rule, those being the severity of the charges, the presence of specific suppressed evidence, or other good cause. The structure of the rule creates a presumption that jurors should be entitled to submit questions to witnesses during trial unless there is something compelling about the nature of the particular case. It is up to one or both parties to establish some good reason specific to the particular case to be tried that would necessitate either precluding or limiting jury questions. Experience over the many years in which the rule has been in effect demonstrates that it's very rare when it would be necessary to completely prohibit jury questions, so long as procedures are in place to permit individualized consideration of contemporaneous objections. The rule places responsibility on the trial court to establish procedures to facilitate jury questions. While these procedures may vary from courtroom to courtroom and from district to district, I'd like to propose a series of procedures which I've found to be both efficient and useful in facilitating jury questions to witnesses. First, the rule requires that questions from the jury must be in writing. In this regard, it is helpful to include forms in the jurors' notebooks on which the jurors may write out their questions. Using a form not only assists the jurors, but it is also helpful in ensuring that a good record is made when deciding whether or not the question will be permitted. Second, the rule requires that the question be submitted to the judge. Make sure you discuss the question with the attorneys and entertain any objections before reading it in open court. Attorneys know the facts of their cases and how witnesses are likely to respond to their questions. Attorneys are also knowledgeable of the rules of evidence and are aware of the limits of what a witness can and cannot say. Jurors, however, don't have that same knowledge of the facts and the law. They may ask an inappropriate question or one that opens the door to inadmissible evidence. Thus, the importance of screening the juror's question in advance of reading it in open court. Third, permit the attorneys to complete their examination of witnesses, including redirect and recross, if allowed, before asking jurors if they have any questions. Fourth, be sure to allow counsel to make objections before making any decision on the admissibility of a question. Honestly, this process should take place outside the presence of the jury, either at the bench or sidebar. But make sure this discussion is on the record. In completing the record, make the same findings as to admissibility that you would make for a question asked by a lawyer. Fifth, if the question is allowed, read it to the witness verbatim. To preserve your impartiality, avoid the temptation to rewrite the question or try to figure out what the jury is trying to ask. If the question is objectionable, tell the jury that a question was submitted that cannot be asked of the witness. And if a question or questions are submitted that are not asked, consider instructing the jury in accordance with Pattern Jury Instruction E:10 as to the effect of questions submitted by jurors that were not asked. Sixth, if a juror's question or questions are asked of the witness, permit the attorneys the opportunity to ask brief follow-up questions based upon the juror's questions. When implementing your procedures for jury questions, it is helpful to explain those procedures to your jury before you commence the evidentiary phase of the trial. Along with this video is an example of a script that summarizes the procedures I've just discussed. While the form of your orientation may vary from this script, it's important that the jury understand how they will be allowed to inquire of witnesses during their time in your courtroom. Finally, I'd like to submit 3 general practice pointers. First, as with all aspects of any trial, be very conscious of your record. In the context of jury questions, make sure that each question submitted by a juror is part of the record. Read each question into the record. Ensure that all discussions with counsel about the questions and any objection raised are made on the record. If there are multiple questions or subparts of questions, number or letter them and make sure the record reflects your ruling as to each question and each subpart. Second, when considering jury questions, err on the side of caution. Jury questions can be enlightening and useful in clarifying issues for the jury. They can also open up a can of worms and invite irrelevant or prejudicial lines of inquiry. So be cautious. If the question submitted is questionable, if it raises red flags, if it has the potential to take the jury down the wrong path or open up prejudicial lines of inquiry, err on the side of caution. Be liberal in the exercise of your discretion under Rule 403. It is very unlikely that the failure to ask a question submitted by a juror will be error or grounds for reversal on appeal. And finally, while any given procedure for facilitating jury questions may vary from the procedure I've just outlined, it is incumbent on each trial court to establish a set of procedures. Once established, stick with them. You will find that if you implement the same procedures in the same way for every witness, for every trial, jury questions will become a smooth and integral part of witness examination. The second context in which jurors are permitted to interact with the trial court during trial arises when jurors submit questions during their deliberations. With respect to mid-deliberation jury questions, Colorado has adopted Standard 15-4.3a of the ABA Standards for Criminal Justice. That standard states that if a jury during deliberations desires to be informed on any point of law, they shall be so instructed in the courtroom unless they may be adequately informed by directing their attention to the original instructions, or the request concerns matters not in evidence, or questions which do not pertain to the law of the case, or the request would call upon the judge to express an opinion about factual matters that are properly to be considered by the jury. We presume that a jury understands the instructions it is given. However, when the jury indicates to the judge that it does not understand an element of the offense charged, or some other matter of law central to the guilt or innocence of the accused, the judge has an obligation to clarify that matter for the jury in a concrete and unambiguous manner. A jury's mid-deliberation question typically comes in one of three types: questions about the law, questions about the facts, and questions about how to apply the law to the facts. Different rules apply with respect to each type of question. If the question is asking about a point of law, the trial court has a duty to endeavor to provide an answer or provide a supplemental instruction unless the answer is obvious from reading the initial instructions. If the question is asking about the facts or the evidence, the court may not provide an answer or provide clarification, as the jurors are the sole arbiters of the facts. The most difficult area involves questions as to how the law applies to the evidence received during the trial. As a general matter, a court may clarify the law if possible, but it may not express an opinion as to how the law applies to the evidence presented in the case. As an example, let's assume that the jury is deciding a kidnapping case and are instructed that the elements of the offense are that the defendant, knowingly, seized and carried any person from one place to another without his consent and without lawful justification. Let's now assume that the jury, during their deliberations, submit the following questions. Question number 1, please clarify the term knowingly. This is a question that raises a point of law. So the analysis is whether this is a question that can be answered by referring the jury back to the original instructions, or is further clarification necessary. Here, there should be a statutory definition clearly stated in the original instructions, so an appropriate response would be to refer the jury back to the original instructions. Question number 2, does the defendant have to know that the victim didn't consent? Like the first question, this question again raises a point of law. But the point of law raised in this question is one that may not be clearly discernible to a lay jury from reading the original instructions, so a supplemental instruction is appropriate. Avoid responding in a way that injects an opinion as to factual determinations. Here, for example, a supplemental instruction might state, The mental state of knowingly applies to the element of without consent. Question number 3. Did the victim agree to get into the defendant's car? Here we have a question that asks about a factual issue. Any comment or clarification on this factual question by the court may well constitute error. An appropriate response may be, this is a question of fact that the court is not permitted to answer. Question number 4. Does moving the victim from the living room to the bedroom constitute seized and carried? This is a question of how the law relates to particular evidence in the case. The response from the court cannot be one that answers the factual inquiry or expresses an opinion about how the jury should apply the law to the specific factual circumstances. But the court may be able to clarify the jury's thinking as to how they might analyze the facts by providing further clarification of the law. For example, the court might provide a supplemental instruction based upon case law, which discusses what constitutes seized and carried, such as seized and carried means any movement, however short in distance. In responding to mid-deliberation questions, like every other aspect of the jury trial, it is imperative to be aware of your record. First, make sure the question is submitted in writing. Let the jury know about this in advance by including an instruction like Pattern Jury Instruction E:09 in your initial jury instructions. And make sure your bailiff knows to instruct the foreperson to reduce any verbal questions to writing. Second, discuss the question with counsel and the defendant outside the presence of the jury, but on the record. In doing so, read the question and the proposed answer into the record. Third, reduce the proposed answer to writing and then either read that answer to the jury in open court or submit the written response to the jury, or both. Fourth, retain all written questions and all written responses in the court file. Finally, I'd like to suggest the following practice pointers. First, responding to jury questions during deliberations is a critical stage of the proceedings. It is constitutional error for the trial judge to respond to an inquiry from the jury without first making reasonable efforts to obtain the presence of the defense counsel and the defendant. So, however anxious you are to respond to the jury's question, and no matter how clear-cut you think the answer may be, make sure that both the district attorney and defense counsel are present when addressing mid-deliberation jury questions. Also, make sure that the defendant is personally present unless his or her presence is personally waived. Second, when responding to a jury's mid-deliberation question, address only the question being asked by the jury and narrowly tailor the response to just a question asked by the jury. Don't try to delve into the jury's mind or inject yourself into what you think they're asking or struggling with. Just answer their question as precisely and as narrowly as is possible, and don't go beyond what they're actually asking. If the question from the jury is unclear or ambiguous, don't speculate about the meaning of the question, even if you're pretty sure your guess about what the jury is asking is accurate. Instead, send back a note asking the jury to clarify the question. Of course, you must first discuss the question with the parties and the defendant on the record outside the presence of the jury. Third, involve counsel in formulating a response even if you think you know the appropriate answer and even if you prepared an answer in advance. Get input from both sides. Often one or both will agree with your initial proposed response. If there is disagreement, actively work with the objecting party to formulate a response that addresses issues raised by the objection. The record will be much stronger on appeal if all counsel are in agreement as to the response to the question, even if that response turns out to be incorrect. And finally, anticipate potential issues that may arise during the jury's deliberations that may lead to a question or to a communication with the jury, and address them with the attorneys and the defendant before recessing for the jury's deliberations. For example, if there are exhibits of a testimonial nature, such as an audio or videotape of a witness or the defendant, familiarize yourself with the rules regarding the jury's access to such exhibits. Discuss those issues with the attorneys and the defendant, and, if possible, decide in advance what restrictions or limitations, if any, may be required on the jury's access to or use of those exhibits during their deliberations. Jury questions asked either of witnesses during trial or of the court during deliberations can be distracting. They can slow the process. They can raise challenging issues. But indulging such questions and instituting procedures and policies to facilitate jury questions empowers and engages jurors and can enhance their ability to understand the facts and the law as jurors pursue their truth-finding function.